For our second speech today, isn't it appropriate that the husband and wife Smith team is also handling the husband and wife presidency of James and Dolly Madison. Our second speaker, Ken, is going to talk about Dolly's husband. You've heard our Linda speak about Dolly Madison. Now Ken will present the significance of her husband, James Madison's impact on our nation. Please help me welcome Ken Smith with James Madison, the 4th U.S. President. James Madison, the 4th U.S. President, Ken Smith.
Thank you very much, Mr. Toastmaster, fellow Toastmasters. I'm sorry I couldn't find a "Hello, Jimmy" to start this off with. We'll just have to go with... Sorry. We're going to have to go with a talk about James Madison. There are a number of things I'm going to go over, some of them very quickly, but they're still important to what happens during his term. It includes his college studies, the fact that he was the most responsible person, in fact, for our Constitution. He's the one that organized people, got them together, and sold them on the idea that the Articles of Confederation had to be scrapped and something brand new written. And then to sell the people on it, he was one of the 3 authors of the Federalist Papers, along with Alexander Hamilton and John Jay, if I recall right. Since they were all signed pluvius, historians have looked at these writing styles and so forth, and they attribute 52 of them to Alexander Hamilton, 28 to James Madison, and 5 to John Jay. He was a champion also of the idea of having a Bill of Rights. He was originally against it because he thought the Constitution was all-inclusive, but then he realized human beings are going to start interpreting it, and he wanted to make sure that some rights were definitely protected. Now, if you remember, the 9th and 10th Amendment made it clear that, especially the 9th, that all of the rights people have are not listed in the Constitution. You have every right there is that isn't specifically given to the states or the federal government. He was Secretary of State under Thomas Jefferson, and this was an important part in the history of the United States, after which he became President of the United States, during which time he declared war on Britain. That was the War of 1812, and often referred to as Madison's War, much as Iraq was called Bush's War. We're going to see a lot of parallels, and we're going to come to understand that the more things change, the more they stay the same. Because a lot of things that happened during our 2nd and 3rd and 4th presidency are just being repeated today. He went to College of New Jersey, which was later renamed Princeton, and he studied Greek and Latin, science and philosophy, and a few other subjects. One of the philosophers he studied was Montesquieu, who was a social and political philosopher, and he's the one who actually proposed the idea of mixing up powers among a number of bodies so that each one is a check or balance against another. And this was a great influence on James Madison as they developed the Constitution. And of course, as I mentioned earlier, he was one of the principal people behind the Constitution. The idea was to develop 3 co-equal branches. Co-equal meant equal to each other, one not superior to another. So if any 2 decided something should be law, the 3rd really was outvoted. We no longer have it that way. And we'll get into that, and that happened during his term as Secretary of State. Let's go on to the Federalist Papers. Again, he was one of the authors because they knew that once they'd written this document, people were going to resist it, even in his home state of Virginia, but most especially in New York. And so a total of 85 papers were written, answering some questions and just explaining some other things, saying what the Constitution was about, why it was created the way it was, how we are all protected as a result of the way it was created. And as I mentioned earlier, he was one of the principal pushers for the Bill of Rights as well. The Constitution, of course, is a living document. Long before the Supreme Courts or other people started calling it a living document with a different meaning. It's a living document because you can amend it, you can change it. And the Bill of Rights were the first 10 changes to it. Now let's get into how the Supreme Court became the supreme branch of the 3 branches of government. And you're going to have to follow this one closely. First, the incoming president at the time, the 3rd president, was Thomas Jefferson. And some significant things happened on his first day in office because some significant things happened on John Adams' outgoing presidency day, March 3rd. So March 3rd and March 4th are 2 very important days. And this does involve James Madison as Secretary of State under Thomas Jefferson. And then a peculiar thing, we have the recently confirmed new Chief Justice of the Supreme Court still acting as Secretary of State for John Adams. Now these are 2 different parties. The Federalists were John Adams' party, and he had a legislative body that was primarily Federalist, so he got everything he wanted from them. When Thomas Jefferson came in with the newly created Democratic Republican Party, the Congress also changed because people apparently were not happy with the way things were going under the Federalists. So on the last day of John Adams' presidency, in the last year of John Adams' presidency, an act was passed called the Judiciary Act of 1801. This act modified the Judiciary Act of 1789. And it did so by establishing 10 new district courts, expanding the number of circuit courts from 3 to 6, adding additional judges to each circuit, and giving the President the authority to appoint federal judges and justices of the peace. This also reduced the number of Supreme Court justices from 6 to 5, effective on the next vacancy in the court. So on March 3rd, outgoing President John Adams, again of the Federalist Party, appointed 16 federal circuit judges and 42 Federalist justices of the peace. And then these appointments were approved en masse by the Federalist majority in the Senate. And then he asked John Marshall, who was acting as Secretary of State but was also going to be the Chief Justice, to deliver the commissions to those who were appointed, because the appointment itself wasn't complete. You actually had to have the official from the government hand them their commission. And since this was on the last day, and not everyone was right around there in DC, some of them got delivered and others did not before Jefferson took office the next day. So he was unable to deliver all these commissions, and John Marshall assumed the incoming Secretary of State James Madison would deliver the rest. On March 4th, the third United States President, Thomas Jefferson, orders the remaining commissions not to be delivered. The newly sworn-in Republican 7th Congress immediately passed Judiciary Act of 1802, which reversed the Judiciary Act of 1801 and restored the Judiciary Act of 1789. Since William Marbury's commission was not among those delivered, Marbury then filed a petition for writ of mandamus, which is a writ to comply, directly with the Supreme Court to force the Secretary of State, James Madison, to deliver the commission. The court must have original jurisdiction over a case in order to hear it, because it was given directly to the court. There's a difference. Original jurisdiction means you originated. Appellate jurisdiction is it originated somewhere else and comes to you. And these are spelled out in the Constitution. And the problem is the Constitution does not grant original jurisdiction to the Supreme Court over federal statutes, and still doesn't today. Here is Article 3, which talks about the Supreme Court, Section 2, Paragraph 2. In all cases affecting ambassadors, other public ministers, and consuls, and those in which a state shall be party, the Supreme Court shall have original jurisdiction. Notice it does not say federal statute law. It does not give original jurisdiction to federal statute law. In all other cases before mentioned, the Supreme Court shall have appellate jurisdiction, both as to law and fact, with such exceptions and under such regulations as the Congress shall make. So the Congress can decide when it passes a law that this is not subject to judicial review. So there were some issues before the court. First, does Article 3 of the Constitution create a floor or original jurisdiction which Congress can add to, or does it create an exhaustive list that Congress can't modify at all? The second issue then is, if Article 3's original jurisdiction is an exhaustive list, but Congress tries to modify it anyway, who wins that conflict? Congress or the Constitution? And more importantly, who is supposed to decide who wins that conflict? The constitutional issue on which Marbury v. Madison was decided was whether Congress could expand the original jurisdiction of the Supreme Court or not. So the decision. Marbury argued that the Constitution was only intended to set a floor for original jurisdiction. Marshall found that Marshall disagreed and held that Congress does not have the power to modify the Supreme Court's original jurisdiction. Of course not. Amendments modify it, and amendments have to be passed by 3/4 of the states. So Marshall did find that the Constitution and the Judiciary Act were in conflict. On February 24, 1803, the court rendered a unanimous 4-0 decision that Marbury had the right to his commission, but the court did not have the right or the power to force Madison to deliver the commission. Acts of Congress that conflict with the Constitution are not law, and the courts are bound instead to follow the Constitution, affirming the principle of judicial review. Unfortunately, that phrase, judicial review, is something they did not have the power to do. So here's the conflict of interest. Jefferson disagreed with Marshall's reasoning in this case, and I'll quote him. "You seem to consider the judges as the ultimate arbiters of all constitutional questions. A very dangerous doctrine indeed, and one which would place us under the despotism of an oligarchy. Our judges are as honest as other men, and not more so. they have, with others, the same passions for party, for power, and the privilege of their core. Their power is the more dangerous as they are in office for life and not responsible, as other functionaries are, to the elective control. The Constitution has erected no such single tribunal, knowing that to whatever hands confided with the corruptions of time and party, its members would become despots. It has more wisely made all of the departments co-equal and co-sovereign within themselves. So we have 3 co-equal branches, huh? Well, let's say we have 3 sheep, and they vote on what's for dinner. But one of them is a wolf in sheep's clothing. What happens? Does majority rule? I don't think so. Lastly, the War of 1812. This happened shortly after Madison was elected. It was a war that originated between Great Britain and France. Both are confiscating our ships and cargo if they were entering their enemy's domain, and Madison decided to embargo and then finally to go to war with Britain, and eventually we won, but we lost the White House and some other things in the process. Mr. Toastmaster.
Not the bullet right there.
Very
Quick wrap
good
up.
timing.
Yeah, that's
Well, thank you, Ken. I think you missed your calling. You should have been a constitutional lawyer. But it's great as a hobby, too.